Question number 951. Testimony of hostile witness is to be rejected outrightly, partially rejected, partially accepted, considered with caution and be corroborated. Here correct answer is option D, considered with caution and be corroborated. Question number 952. Hostile witness means an unfavorable witness, a witness who is desirous of telling the truth, a witness who is not desirous of telling the truth, an overpowered witness. Here correct answer is option A, an unfavorable witness. Question number 953. By which of the following ways Indian Evidence Act 1872 the credit of a witness may be impeached by adverse party? Options are: by the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit. Option B, by proof that the witness has been bribed or has been accepted the offer of bribe. C, by proof of the former statement is inconsistent with any part of his evidence which is liable to be contradicted. And evidence D, all of the above. Here correct answer is option D, that is all of the above statements are correct. Question number 954. Which of the following provisions of the Indian Evidence Act was omitted by the Amendment Act of 2002? Correct answer is option C, that is section 155 clause 4 of the Indian Evidence Act. Question number 955. Which option is available to a commissioner when a party seeks permission to cross-examine his own witness? Option A, he can permit the party to do so. He cannot permit the party to do so. He may ask the party to first obtain permission from court under section 154 of the Evidence Act. Option D, he can permit the party to do so with the consent of the opposite party. Here correct answer is option C. He may ask the party to first obtain permission from the court under section 154 of the Indian Evidence Act. Question number 956. Former statement of a witness may be proved to corroborate later testimony as to the same fact as provided under section dash of the Indian Evidence Act. Correct answer is option A, that is section 157 of the Indian Evidence Act. Question number 957. A statement recorded by investigation officer under section 161 CRPC can be used for contradiction, for corroboration, to refresh the memory of a witness. None of these. Here correct answer is option A, that is for contradiction. Question number 958. Statement of an injured person is recorded as dying declaration. However, he survives. His statement is admissible under which section of the Evidence Act? Correct answer is option D, that is section 157 of the Indian Evidence Act. Question number 959. Which one of the following statement is correct? A dying declaration made under section 32 of the Indian Evidence Act 1872 is subject to the control of section 164 of the Code of Criminal Procedure, section 161 and 162 of the Code of Criminal Procedure, section 52 and 54 of the Indian Evidence Act, section 158 of the Indian Evidence Act. Here correct answer is option D, that is section 158 of the Indian Evidence Act. Question number 960. Under which section the facts proved under section 32 and 33 can be contradicted as per the Evidence Act? Here correct answer is option C, that is section 158 of the Evidence Act. Question number 961. Under which provision a witness can refresh his memory? Here correct answer is option B. Under section 159 of the Indian Evidence Act, witness can refresh his memory. Question number 962. Under section 159 of the Evidence Act provides for. Here correct answer is option C, that is witness can refresh his memory. Question number 963. Which of the following sections of the Indian Evidence Act has been amended by the Criminal Law Amendment Act 2018? Select the correct answer with the help of the code given below. Section 53A, section 119, section 146. Here correct answer is option C, that is only 1 and 3 are correct, that is section 53A and section 146. Question number 964. The examination of a witness by the party who calls him. Here correct answer is examination in chief. Witness who lets down the party who calls him. Here correct answer is option B, that is hostile witness. Examination of a witness by the adverse party. Here correct answer is cross-examination. Examination of a witness by the adverse party, that is cross-examination. Question suggesting the answer which the person putting it wishes or expects to receive. Here correct answer is leading question. Question suggesting the answer which the person putting it wishes or expects to receive is leading question. So by going through these options, correct match here will be option B. Question number 965. Indecent and scandalous question. Here correct match is section 151. Impeaching the credit of witness. Correct match is section 155. Question: intent to insult or annoy. Here correct match is section 152. And the last question by party to his own witness is section 154. Indecent and scandalous question, section 151. Impeaching credit of witness, correct answer is section 155. Questions intended to insult or annoy, section 152. Question by party to his own witness, section 154. Question number 966. Match the following and tick the correct code. List first and list second. Section 60, oral evidence is the correct answer. Section 141, leading question. Section 154, hostile witness. And section 159, refreshing memory. Here by going through these match, the correct option is option A. Question number 967, match list first and list second. Refresh the memories, correct answer is section 159. Dying declaration, correct answer is section 32 clause 1. Leading question, correct match is section 141. Hostile witness, here correct match is section 154. By going through these matches, the correct answer here will be option A. Question number 968. Which one of the following is not correctly matched? Options are section 113B, presumption as to dowry death, section 137, examination in chief, section 151, indecent and scandalous question, section 154, impeaching credit of witness. Here correct answer is option D. Section 154, impeaching credit of witness is not correctly matched. Question number 969. The following is not the example of best evidence rule. Section 60, section 64, section 91, section 164. Correct answer is option D. Section 164 is not the example of best evidence rule. Question number 970. A judge in India is not empowered to put questions on his own to the witness or to the parties, is empowered to put questions on his own to a witness or to the parties according to his sweet will, is empowered to put questions on his own to the witness or to the parties in order to discover or to obtain proper proof of relevant fact, is not empowered to put questions on his own to a witness. Here in question number 970, correct answer is option C. A judge in India is empowered to put questions on his own to the witnesses or to the parties in order to discover or to obtain proper proof of relevant facts. Question number 971. Court question under section 165 of Evidence Act can be put to, correct answer is any witnesses, any parties. C is the correct answer. Question number 972. Under which section of the Indian Evidence Act a judge is empowered to ask any question relevant or irrelevant to a witness or a party to a suit? Here correct answer is option B, that is section 165. Question number 973. Power of a court to suo motu explain any person or at any stage is under. Here correct answer is option C, that is section 165 of the Evidence Act. Question number 974. Which of the following chapters of the Indian Evidence Act deals with witnesses? Here correct answer is option D, that is chapter 9. Question number 975. Which section of the Evidence Act makes that the provision that there shall be no new trial on the ground of improper admission or rejection of evidence? Here correct answer is option C, that is section 167. Question number 976. Mode of proof of a custom is contained in section 32 clause 4 of the Evidence Act, section 32 clause 7 of the Evidence Act, section 48 of the Evidence Act, all of the above. Here correct answer is option D, that is all of the above. Section 32 clause 4, section 32 clause 7 and section 48 of the Evidence Act, mode of proof of a custom is contained. Question number 977. Section 27 control. Section 24 of Evidence, section 25 of the Evidence and section 26 of the Evidence Act. Here option D is the correct answer. Question number 978. Facts discovered in consequence of a joint information. Option A are not admissible and cannot be used against any of the accused person. Option B are admissible, can be used against any one of the accused person, are admissible and can be used against all the accused person. Both B and C are correct. Here correct answer is option A, are not admissible and cannot be used against any of the accused person. Question number 979. Declaration in the course of businesses are admissible under section 32 clause 2 of the Evidence Act. Here option B is the right answer. Question number 980. Oral evidence under section 60 of the Evidence Act may be direct only, hearsay, both A and B, either A or B. Correct answer is option A, that is direct only. Section 60 of Evidence Act. Oral evidence under section 60 of Evidence Act is direct only. Question number 981. Maxim omnia prosecutor ret issa acta means? Here correct answer is option A, that all acts are presumed to be rightly done. Question number 982. Principle of omnia prosecutor ret issa acta is contained in? Correct answer is option B, that is section 79 of the Evidence Act. Question number 983. Section 79 of the Evidence Act applies to certified copies issued by the government officer, certified copies issued by the government officer, other documents duly certified to be genuine by the government officer, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 984. Section 90 of the Evidence Act applies to? Here correct answer is option C, that is both testamentary and non-testamentary document. Section 90 of the Evidence Act applies to both testamentary and non-testamentary documents. Question number 985. Section 88A of the Evidence Act applies for? Presumption as to electronic message forwarded corresponds with the message as fed in the computer. Presumption as to the person by whom message is sent, both A and B, and option D, only B but not A. Here correct answer is option A. Section 88A of the Evidence Act provides for presumption as to the electronic message forwarded corresponds with the message as fed in computer. Question number 986. Section 91 of the Evidence Act prohibits admission of oral evidence to prove the contents of a document where the writing is a fact in issue. Option B is the right answer. Question number 987. Oral evidence of a fact invalidating the document is admissible under proviso 1 of the section 92 of the Evidence Act. Option A here is the right answer. Question number 988. Under proviso 2 of the section 92 of the Evidence Act, oral evidence is admissible where the instrument is silent on the matter sought to be proved and the agreement to be proved is consistent with the terms of the documents. Here option B is the correct answer. Question number 989. Extrinsic evidence to show the meaning or supply the defects in an instrument is prohibited under section 93 in respect of? Here correct answer is option A, that is ambiguous patents. Question number 990. In criminal trials, it is bound to presume the absence of the case of the accused following any general or special exceptions to the proviso to the provision under which the accused is charged. Here option C is the correct answer. Question number 991. In cases a child is born within 280 days of the dissolution of marriage, the mother remaining unmarried, the presumption of legitimacy of child under section 112 of the Evidence Act arises irrespective of whether father is alive or dead on the day the child is born. Question number 992. Estoppel should be specifically pleased. Option A here is the right answer. Question number 993. A person is competent to testify if he understands the questions put to him, if he is able to give rational awareness to those questions, if has both A and B. Here correct answer is option C. Both A and B are the correct answer. Question number 994. Privilege under section 121 of the Evidence Act is available to an arbitrator. Question number 995. Privilege in respect of husband and wife under section 122 of the Evidence Act relates to question which a witness cannot be compelled to answer, question which a witness cannot be permitted to answer, both A and B, only B and not A. In 995 correct answer is option C, that is both A and B. Question number 996. Admissibility of the evidence under section 122 of the Evidence Act has to be adjudged. Option A, in the light of the status on the date when the communication was made. Here option A is the correct answer. Question number 997. Protection under section 122 of the Evidence Act is available to? Correct answer is option B, that is husband and wife as a witness. Question number 998. Protection under section 122 of the Evidence Act is? Correct answer is option B, that is not confined to confidential questions only but extends to communication of whatever nature. Question number 999. Section 124 of the Evidence Act provides for the privilege in respect of official communication. Here option B is the right answer. Question number 1000. After re-examination of a witness, the adverse party has a right to further cross-examination the witness only when a new matter is introduced in the re-examination. Here option C is the right answer. Question number 1001. Under section 145 of the Evidence Act, a witness may be cross-examined as to previous statement in writing. Option A, without proving the same and without showing the same as witnesses. Here option A is the correct answer. 1002. Objection as to admissibility of a document in evidence can be made at first opportunity when the document is rendered in evidence. 1003. A party or person who calls the witnesses can be permitted to cross-examine the witness so called by him as provided under Section 154 of the Evidence Act. 1004. The Delhi High Court issued guidelines for the protection of witnesses in, correct answer is option A, that is 𝐓𝐵 case 2003. Question number 1005. Relationship is not a factor to affect the credibility of a witness held by the Supreme Court in, option A is the right answer, that is S. Darshan Reddy versus State of Andhra Pradesh, AIR 2006, Supreme Court. Question number 1006. In which case Supreme Court held that material evidence and not the number of witnesses has to be taken note to ascertain the truth of the allegations made. Here correct answer is option B, that is Syed Ibrahim versus State of Andhra Pradesh, AIR 2006 is the correct answer. Question number 1007. It is well settled law that the rule of prudence requires that the evidence of an accomplice should ordinarily be corroborated by some other evidence. It was held by the Supreme Court in, correct answer is option A, that is Francis Stanley versus Intelligent Officer, AIR 2007, Supreme Court. Question number 1008. In which of the following cases Supreme Court held that test identification parade is only an aid to investigation? The practice is not born out of prudence. Correct answer is option A, that is Siddharth Vashisht alias Manu Sharma versus State NCT of Delhi, AIR 2010. Question number 1009. A dying declaration is relevant evidence under Section 32 of the Evidence Act, notwithstanding it being hearsay evidence, because if a person is dead and anything said by the person as to the cause of the death is relevant, since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit the said statement. Question number 1010. The question in cross-examination, option B is the right answer, need not to be confined to the fact testified by the witness on his examination in chief. 1011. Which section of the Indian Evidence Act deals with hostile witness? Here correct answer is option B, that is Section 154 of the Indian Evidence Act. Question number 1012. By which of the following ways Indian Evidence Act credit of a witness may be impeached by the adverse party? Here correct answer is option D, that is all of the above. By the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit, by proof that the witness has been bribed or has accepted the offer of bribe or has received any other corrupt inducement to give his evidence, by proof of the former statement inconsistent with any part of his evidence which is liable to be contradicted. Here all the statements are the correct. Question number 1013. In which of the following cases Supreme Court held that any information or material that is subsequently discovered with the help of voluntarily administered test result can be admitted in accordance with the Section 27 of the Indian Evidence Act 1972? Here correct answer is option A, that is Selvi versus State of Karnataka is the right answer.